Hello friends, in the series on the income tax cases, today we will discuss the case of Assistant Commissioner of Income Tax versus Dr. D.Y. Patil Education Society. This case is reported in 104 ITR Tribunal at page number 296 and the case has been decided by Mumbai ITAT D bench. The date of the judgment is 29th September 2022. The reason for discussing this case is that in this case, the question involved was that for completing the assessment under section 153C, which sixth assessment year is to be taken, whether that sixth assessment year is to be taken from the date of the search or whether 6 years are to be computed from the date on which the assessing officer who is going to make the assessment under section 153C has received the seized material and the documents from the assessing officer of the person to whom the search has been made. As all we know that for the searches which have been done before 1st April 2021, the assessment of the assessee is to be done under section 153A and 153C respectively. For assessees on whom the search has been conducted, assessment is done under section 153A, and for other assessees whose documents are found at the place of the assessee to whom the search has been made, the assessment is done under section 153C. In this case, the search on one of the assessee was conducted in July 2016. So for that assessee, the 6th year is to be calculated from the date of search, that is 29th July 2016. But this information was handed over to the assessing officer of the assessee whose documents have been found in the search of the person. In that assessee, the 6th year is to be calculated from the year in which the documents have been handed over to him. In this case, the documents were handed over in September 2018. So, the last assessment year is 18-19 and going back 6 years back. In this case, the documents were handed over in September 2018. So, the 6 previous years were 2018, 17, 16, 15, 14 and 13. Means the assessing officer can do the assessment only for the assessment year 13, 14, 14, 15, 15, 16, 16, 17, 17, 18 and 18, 19. But in this case, the assessing officer has done the assessment of the assessment year 2011-12 and 12-13 and so on. So the assessee was contesting that the assessment for the assessment year 11-12 and 12-13 are bad in law because section 153C does not give the power for making the assessment of those years. When the assessments were made, the CIT appeal upheld the order of the assessing officer, but this ground was taken by the assessee before the ITAT also, and the ITAT held that in this case the assessment for the assessment year 11-12 and 12-13 are not valid because they do not cover in the 6 years from the date on which the documents and the seized material has been handed over to the assessing officer of the assessee on whom the search has not been made. Friends, this case is very important because it is a general perception among the people, among the professionals, that the assessment for both the assessees, the assessee on which the search is made and the assessee on which the search is not made, the assessment is to be done for the 6 years, counting 6 years back from the date of the search. But there is a distinction between both the assessees. In section 153A, assessments, the date of search is important, and in case of other assessee, the date on which the seized material and other information has been handed over to the assessing officer of the other person is important. Friends, whenever we are contesting our point, these dates are very important. We have to read the section, we have to read the case laws relevant to that, because sometimes it may happen that we are not very strong on our merits. But these points give a very strength to our litigation importance in the case of ITAT and in the High Court, because generally these type of grounds are not taken care of by the CIT appeals. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus Dr. D.Y. Patil Education Society. This case has been reported in 104 ITAT Tribunal at page number 296. The matter has been decided by Mumbai ITAT D bench and the date of the judgment is 29th September 2022. Thank you, friends.